settlement arrangements in the WTO, governments have standing to bring a complaint against another government. It's not a private firm versus another private firm, or a private firm against a government, or a labor union against a company in another country. It is about governments versus governments. They're the only ones who can bring a case in front of the WTO dispute settlement body. If there is a complaint, after an initial set of consultations, there's a panel of experts that are chosen by consensus among the parties involved, who will evaluate whether or not the country being accused is living up to its obligation under the international trade agreements. If a panel rules that a country is not living up to its commitments, it can be appealed to a group of jurists, which is essentially like a Supreme Court of international trade, where this group of experienced judicial players will evaluate whether or not the country is living up to its obligations. But it's important to note that the WTO cannot require that a government change its policies. What they rule on is whether or not a country is being inconsistent. There is no rule that a foreign government official, head of state, can be imprisoned in Geneva if they decide not to change their rules after an adverse dispute settlement body ruling. So the options are really the following. One, if a country loses the case, they can decide to comply. They can say, all right, we'll change what we're doing. But it's important to note here that the compliance is only moving from that day forward. There's no compensation for past loss. So if a country puts on a trade restriction in a way that's inconsistent in 2013, the case is decided in 2015, and the WTO says, well, you've lost $100 million worth of sales because of this. The government only need to change its policies at that stage. There's no compensation for the $100 million lost in past sales. You simply go forward. If a country decides not to change its policies, which it's perfectly within its rights to do so, there can be retaliation that's approved by the WTO. The WTO will say, okay, this country is not living up to its agreements, they're not changing, you can now impose $100 million worth of trade sanctions, trade barriers on the violating country with our approval. So you get this neutral third party saying the country has done wrong, it's not changing its policies, okay, now you can retaliate. Or the offending government can offer compensation. It can say, well, I don't really want to change this policy because of domestic political concerns, but I will lower my trade barriers in some other way, or I will do something that you like in some other area of our relationship so that you will feel like you're getting compensated for the loss from the commercial problems that has been found to be in violation. So one way to think about all of this is that the dispute settlement body really is this neutral third party that rules that a country has been a very, very, very bad boy. They cannot force the government to change. What they can say is that you're, in a very public way, that you're not living up to your obligations, and you face these different options. One thing to note about this is that these options are really not that different than what would be the case if there was no dispute settlement body. Two countries have a problem and somebody complains. Well, you can either come up with some sort of agreement to change the policy. The offended government can retaliate, or the offending country could offer some compensation. So there's really no essential difference with the options available to a government with the dispute settlement body or without. The key difference is that it's a third party that's making the assessment of living up to the obligations. And there's some advantages with that arrangement. Now, currently, the World Trade Organization is operating under the current set of arrangements that were negotiated in the Uruguay round some 20 years ago in 1994. In 2002, there was a new round of negotiations launched to focus especially on developing countries. Now, this was the so-called Doha Round, or development round. And this is a very complex set of negotiations dealing with a number of problematic areas. What I'd like to focus on here is that there has not been a consensus reached. As of 2013, this whole process is stalled. Now, one of the things that is now different is that you have important new players that are not taking the decisions of the US, the EU, Japan, and Canada, the so-called Quad, as the final say. Instead, China, India, Brazil, and now Russia are not shy about saying they would like a different arrangement. In fact, many developing countries who are now fully members of the WTO now have the ability to block an agreement going forward if they don't feel it's in their interest. So this has made a consensus of completing the Doha round very much more difficult than in past rounds, where it was a smaller group of countries that were negotiating. And what has increasingly been the case is that countries are turning more towards bilateral and regional trade agreements as a way to move trade liberalization forward. For example, the US-Korea agreement. The European Union has agreements around the world. Mexico has agreements, free trade agreements with a number of countries around the world. The US in 2013 is in the process of negotiating a trans-Pacific partnership with countries of the Pacific Rim. Also, the transatlantic trade and investment partnership with the EU. All of these reflect the inability of countries to come to an agreement with the broader 159 members of the WTO. Instead are moving towards more limited agreements in terms of the number of countries. So to summarize, the WTO now encompasses almost all of international trade and GDP around the world. It is a broad set of relationships across the world with existing arrangements that have commitments of countries to maintain relatively free flow of goods. There are areas where it is much more difficult to move forward, perhaps. The focus of the WTO system is on non-discrimination. You treat other WTO members no worse and, in principle, no better than other members. The WTO membership comes with rights and it comes with responsibilities. You have certain abilities to complain through a dispute settlement process about other countries not living up to their agreements. You also have responsibilities to treat other WTO members in a similar way. So, as in every kind of arrangement that has contract-like features to it, countries have to live up to their side of the bargain, even as they expect others to do the same. Going forward, the whole process of a single undertaking based on consensus is going to make the process of expanding the commitments under the WTO much more difficult. As a practical matter, it's hard to get 159 countries to agree on a whole range of things. So the WTO system, and it's as a successor to the GATT, has ushered in an incredible increase in the amount of trade liberalization across the world that started in 1948. It has been a source of robust economic growth and increased trade flows. The question in many people's minds is whether or not that system, put together in the late 1940s, will go forward at least in the same way. That is where the focus of trade liberalization may occur. It may end up being more at the regional and bilateral level.